Good morning and welcome to the First District Court of Appeals. We have two cases to be argued this morning. When I say the name of your case, if the attorneys could please rise and state your readiness to proceed. The first case is Hartford Fire Insurance Company versus DeBraw-Kumpel.
Good morning, Your Honor. Zach Ransel, on behalf of Hartford and New York Ready to proceed.
Okay, thank you.
Good morning, Your Honor. Mike Caligaris, on behalf of DeBraw-Kumpel, ready to proceed.
Okay, thank you.
And Your Honor, Brian Winchester on behalf of third-party defendant, Petco E&A Services, now known as IMEG Corporation. I know it's a mouthful, but I'm ready to proceed.
Okay, thank you. Okay, then our second case is the Glyer Company versus Board of Trustees of the Public Library of Cincinnati and Hamilton County.
Your Honor, C.J. Schmidt on behalf of the Glyer Company, and we're ready to proceed.
Your Honor, Michael Friedman on behalf of the Hamilton County Public Library. We're ready to proceed.
Okay, thank you. And I understand that the appellees in the first case, you're splitting time. Mr., and I'm going to butcher this and I apologize, is it Caligaris?
That's correct.
Oh, wow, I got it right. Okay. You're going to take 8 minutes and then you're going to take 7.
Yes.
Okay, okay. Mr. Ransel, whenever you are ready, you may come up and get started. Would you like to reserve any time?
I'd like to reserve 3 minutes, please.
Okay. Oh, and just so you know, I will have the light system going. It'll be on the podium. The green light means go. Yellow light means you have about a minute, and the red light means that your time has expired. So whenever you are ready, you may come up.
May it please the court. My name is Zach Ransel. I'm here on behalf of the Hartford. Before the court today is a property subrogation dispute. I'm going to jump into the subrogation waivers right away because I think that's the important thing that we're here to talk about. Before I do that, I want to talk briefly about the construction contract documents themselves. What we have before the court today are an owner-architect agreement. It's an AIA template that is typically used between owners and architects, and it's a document that was prepared by the AIA for this use.
And let me just, looking over these agreements, it seems to me that part of the purpose of these agreements is to shift risk of loss to ultimately insurance companies, because if that's not the case, then each sub, each general contractor, each owner, each architect, they all have to insure against the same basic losses. And so I guess just looking at it from a policy standpoint and how these contracts are designed, I mean, they are form contracts. What is wrong with shifting that risk of loss to the insurer? I mean, you guys don't, obviously, you don't have to insure it if you don't want to. You can say, no, we refuse, or we want to increase our premiums.
No, I agree that the general intent of these AIA documents is to waive subrogation. Our position in this matter is that there's a specific exception that allows the Hartford to pursue subrogation. So generally, that's right. The idea is to prevent subrogation during construction so you don't have contractors and subcontractors and owners pointing fingers at each other, which would slow down construction. In this particular case, though, we've got certain language that I believe gives the Hartford a path to pursue subrogation, and that's the exception that's set forth in the general conditions that were incorporated into the contract documents.
I'm sorry, in the A1A1 contract or your actual policy?
No, the A201 general condition of the contracts for construction, which is incorporated into the B101
Sure.
architect-owner agreement.
Right, I need a diagram, but go ahead.
Yeah, it's confusing, and I understand completely. So it's kind of the reason why we have this, what I talk about in the briefs is the conflict in the first place, which is we have two waivers of subrogation provisions, one that says X and the other one that says Y.
Are you talking about the difference between, and I may be getting the numbers wrong, 8.2 and then the 11 point whatevers?
That's correct.
But I guess I had trouble following that argument because the 8.2 is talking about owners versus architect. And then the others are talking about the contractors. So to me, it seems like two different topics. Am I not understanding that correctly?
That's not our position. I think the 11 document, 11.3.1 actually applies to and for the architect and the owner as well. So 11.3.1,
That was one thing that I wasn't clear from your arguments. Are you arguing that 8.1.2, which I believe comes out of the B101, that governs the subrogation issue, but in the event that it was found to apply to this case, then 11.3.1 and 11.3.2 are in conflict? Or are you understand what I'm saying?
I do.
Okay, as opposed to arguing that they all apply.
no, I'm arguing that it's a little bit different depending on whether it's DeBrock Kemple or Petco. But with respect to DeBrock Kemple,
Right, and I'm only talking about DeBrock
okay,
Kemple, yes.
the argument with respect to DeBrock Kemple is that 8.1.2 in the architect-owner agreement is not applicable to DeBrock Kemple at all because they are not a party that is.
And I understood that part of your argument, so are you saying then we don't even look at 11.3.1?
Correct.
Okay, and that's
But
exactly
why?
what I wanted to clarify.
Why would we not look at that? So like if they're not an owner or architect, okay, so 8.1.2 doesn't apply, so why would we not look at 11.3.1, which talks about owner and contractor relationship?
Yeah, I understood. I do think that 11.3.1 applies to DeBrock Kemple as a party. That's not my argument. I think that if there wasn't the exception set forth in 11.3.2, which expands upon 11.3.1,
When you say as a party, meaning that for subrogation purposes?
subject to the waiver, they are one of the parties that was contemplated to be allowed to enforce the subrogation waiver.
Okay.
As opposed to 8.1.2, which is, they're not a party that is subject to that agreement, or to that provision. And the reason that DeBrock Kemple, the reason that 11.3.1 is not applicable to what we have in front of us, the policy here, is twofold, maybe even threefold. So in order for 11.3.1 to be applicable, it's got to be applicable, the property, the policy that it's applicable to is a policy required by the agreement. I don't think there's any dispute that the Hartford's policy that was put in place several years after construction began, during construction, was a policy that was required by the agreement. And then the second condition for this waiver to apply is other property insurance applicable to the project. And for the same reasons, because it was obtained, policy was obtained mid-project, not at the beginning of the project, or wasn't in place at the beginning of the project, that's the reason that 11.3.1 is not applicable to this matter. And that's kind of the gist of it is, where does this property policy fit, 11.3.1 or 11.3.2?
So are you saying it was a brand-new policy, or was it a renewal?
I don't believe it was a renewal because, and there hasn't been ample discovery on that in the trial court, but we know that there was an assignment of the project and the property in 2020.
Right.
So my deduction is that it was a new policy in 2020 because the ownership changed hands.
But at the end of the day, why does that matter? Like, the policy's in effect over when the incident occurred, so, like, why does it matter whether it's new or it's old?
Because with respect to 11.3.1, I think that supports the position that it wasn't obtained pursuant to the construction agreement, because it wasn't in place at that time. And then it wasn't obtained, or wasn't applicable to the project, because just based on common sense, getting a policy that late in the project doesn't seem like it would be.
Well, but by the same token, like if you have a multi-year project, which sounds like this was, then like it would stand to reason that if you have an annual policy that you would need to renew it, or you might find a better deal somewhere else and go somewhere else, like that would seem to negate any policy that was obtained other than at the very beginning of the project.
Yes, I understand that. I still don't, I'm still of the position that I don't see.
And I guess I just don't understand that, because like, if you're insuring everything, then kind of whether you like it or not, you're insuring what's happening on that site, unless you exclude that in the policy, which obviously you can do as the insurer. So again, if I'm misunderstanding something, like, that's why I'm asking these questions, to
No.
make sure I understand.
No, I think you are understanding it. I think, I'll go back to it. I think the 11.3.1, sets forth the conditions for the policies that are subject to it. It's my argument that this policy is not subject to it. In the event that the court were to find that 11.3.1 is applicable to the Hartford's policy, I'll note that 11.3.1 is still limited. It says the scope of this
I
waiver
want to
shall
go
be
back
limited.
to, because you're saying that it doesn't apply to the Hartford's policy because,
It wasn't obtained pursuant to the agreement, and it's not applicable to the project, which is a defined term within
okay,
the
so you're
construction
looking at the
documents.
word obtained, and when I look at the language of that provision, it has the language required. And looking at the contract, it did require for there to be insurance during the term of the construction,
I believe that's accurate.
which makes sense, you know. So I don't know that I think that there may be a difference between required and obtained pursuant to the contract.
And as I was saying earlier, I do think there's still a limitation in the event that 11.3.1 is applicable to the Hartford's policy. It is limited to, I'll just read it, the scope of this waiver shall be limited to damages to the work itself. So that's, I think, an important limitation to the application of that.
I found that language very fascinating because the contract defines project and it defines work. And work is a subpart of the project, but could be the project, okay? But obviously, in this provision, it's using both terms, so they're not intended to, be interchangeable. They're not intended to be the same.
I agree with that.
So my question is like, whose work are we talking about? Who does the work apply to? Does the work apply to, do you understand what I'm saying?
Yes.
Is it the work that DeBra Kemple did? Is it the work that, I'm trying to remember the name of the company that hired them, the project manager?
Danis.
Danis. Is it Danis? Is it, who does that work apply to?
I think they're defined terms within the contract. Section 1.1.3 defines the work, and section 1.
Correct, but it doesn't define in a way that helps me answer this.
Oh, I think the work is defined, is essentially defined as the finished product. And this is the work that, the property that was installed, the HVAC, the carpet, the drywall, stuff like that, the finished product.
So you're defining it as the project then?
No, I think the project is more than that. I think that's all the time I have, unless you want me to continue.
Well, I really would, I would.
No, I think the project is, at least based on the definitions in the contract, is broader. And I think the project includes not just the finished work or the finished product that was installed at the construction site. I think the project involves the entire process of getting the project done.
Well, I mean,
Drawings.
the project is defined in the contracts. The project is defined as the modification of existing 300 square foot facility and the addition of a 75,000 square foot new one-story building. So that's defined in the contract. It's defined at the very, very beginning because it defines what it is that it governs, right?
Yes.
But I'm still trying to figure out the work, who is the work tied to? What party, what company, what entity is the work tied to? in the way that we should be looking at this?
I think it might depend on when, the time period of what we're talking about. We're talking about post-construction or during construction. During construction, the work might be titled to the construction team. After construction is the owner of the project.
It's not titled, but tied to.
Oh, I'm sorry.
Yeah. In other words, it says the work, and it's whose work is what I'm asking. Is whose work are we talking about?
Well, I think it's the work of everybody who performed work on the project, is my understanding of the definition in the contract.
And I wasn't able to clearly understand this. Is the project considered, was the project considered complete before the loss occurred?
Yes, that's my understanding.
The final payment was made?
That I don't know.
Okay, because the final payment is required under the contract. That sort of is what kind of closes the whole thing.
I believe that's true.
Okay, so
We
it's
don't have-
nebulous as to whether we have a complete project then.
We don't have really specific discovery as to the exact date as to when the construction completed and the final payment was made.
Okay, all right, thank you.
Thank you.
Okay, Mr. Caligaris.
Morning.
Good morning.
My name is Mike Caligaris. I represent DeBrock Campbell, the appellee. Judge Ives, it's interesting you bring up the definition of work and whose work are we really talking about in this case?
Because of that language saying, you know, because you have a loss, and the
Correct.
loss was ceiling, walls, blah, 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 right? And I don't think that the loss is going to include replace or repair the HVAC, which was the cause of the loss, right?
Correct, and at the
So
time of the
you
loss.
you get where I'm going with this?
I do, and at the time of the
And
loss.
I know it doesn't help you, but, but it, you know, it's like, I don't, whose work are we talking about here?
Well, and I believe that was the issue in the trial court as well, and that's because the appeal arises out of the appellant's failure to sue the correct party from the onset of the case, and then the latent discovery that I believe they sued the wrong company. And that's because in Ohio, a subcontractor assist, who is DeBrock Campbell in this case, cannot be liable for the negligent design of the engineer of record, who is Petco, the third-party defendant in this case. For over a year of litigation, DeBrock Campbell was the sole defendant, and the Hartford attempted to bring a negligent design claim against the subcontractor assist. And adherence to the subrogation waivers that it found enforceable, with Petco at least, as that was named in the AIA contracts. It was not until that position changed and there was a motion for leave to bring in Petco as a primary defendant that the unenforceable waiver argument was raised and the reason why we're here on appeal. First and foremost, DeBrock Campbell did not know about the subrogation waiver at the time of the suit being initiated. Because we were not party to the AIA contract, we're a successive party. Importantly, under the AIA provisions, the parties.
And that brings, and this is like to me a footnote, because I don't think it changes anything. Looking at the language of the contract, and I know everyone keeps referring to DeBrock Campbell as a subcontractor. The contract defines contractor as those identified in the agreement, and then it defines separate contractors as those that are retained by the owner under separate agreements. So it seems to me that your client is a separate contractor, which is a term that is articulated in 11.3.1.
I believe under 11.3.1, a separate contractor would be DeBrock Campbell, and that the general contractor, Danis, is the only party in which we have privity. However, under 8.1, agent and
And
consultant.
Danis is also not in the agreement.
And
It's not a
Danis-
contractor that is articulated in, if Danis was articulated, then you would be a subcontractor.
And I believe that's because Danis was the original, or was not the original contractor. Upon assignment, there was a shift in the parties, and Danis became the GC.
Okay.
But I do believe that under 8.1, the primary provision, that DeBrock Campbell does qualify as an agent or a consultant of the architect and engineer of record. And that's solely because our entire role on the project was to implement the specifications and requirements of the engineer of record and their design. And that's laid out in contractual form and by process, which
Because
requires.
consultants are also, I mean, it articulates who the consultants are.
And again, I believe at the time, DeBrock Kemple was not even involved in the project, so there was no way to foresee DeBrock Kemple being included in those definitions. But the successive contractor language that requires all the parties that are party to the AIA originally to require the same or similar waivers of subrogation to successive parties, that's a requirement that's put in that provision, and that was what should have occurred throughout this case.
I mean,
or throughout
does
this
it
project.
matter whether DeBrock Kemple is a agent and a consultant as to the architect versus because they were, Dennis hired them and Dennis was in the contract with the owner, or a separate contractor to the owner? Does it change the analysis in any way?
I don't believe any substantive way it would, but I think it is important distinction because, of course, DeBrock Kemple is a agent or consultant of the architect because the design drawings and the plan for the entire project, particularly as it relates to the HVAC work, was the architects and the engineer records design that we had to follow and have stamps of approval throughout every construction phase for any work that we performed. And so for purposes of defining the agency or the consultancy of DeBrock Kemple, it's required by our contract, separate with Danis, the general contractor, that we have oversight, or oversight is given by the architect of record and engineer throughout the entire time we are performing work, and that we must follow their specific intent of the design. And DeBrock Kemple's corporate representative, under oath, testified that I believe that all the work that is complained of in this lawsuit is demonstrative of DeBrock Kemple following the specific intent of PEDCO, now IMEG, meaning that we took the design plans, we performed drawings and computations for their approval. They approved it. Everything is within the specific intent of those designs, and then they were implemented at the site. It was only post-loss, or post-construction, excuse me, and the termination of the construction phase, that this loss occurred. And at that time, the building was turned over to the owner's facility management team, Cushman Wakefield, who's not part of the suit. They are operating the HVAC system at the time of the loss. And there's deposition testimony from the corporate representative of Cushman Wakefield, who was the person in charge, and there's ample evidence in the record that he did make modifications to the HVAC system. He was in charge of overseeing the maintenance of the system, and this is now several months post our work where the loss occurred. But going back to the contractual issues, the big policy exception that has been raised does not apply here, particularly given that we're not in privity with the Hartford, but also because the reliance on that relates to their interest. They quote their interest, meaning the architects, the engineers cannot, there can be an exception to the waiver of subrogation unless there's a written agreement as to their interest. Their meaning the architects and the engineers being named as an additional insured or having an insurable interest. Doesn't apply to DeBrock Kemple or PEDCO in this case, so that exception should not apply. And the policy language of the Hartford cannot dictate or provide more rights to itself other than what its insured specific intent was under the agreement. Under the agreement, the specific intent was to waive subrogation. And simply because Hartford has tried to find a carve-out or exception to that language, cannot increase the rights of their underlying insured. And the specific intent is pretty clear from all three provisions that you read.
But could Hartford have said, and they had a provision similar to this in the policy, but if they'd said, you cannot waive your right to subrogation, I mean, they could have done that, right? And that
their
would have been
insured.
enforceable, right?
Just to clarify, Your Honor, to their insured, you cannot waiver it.
Correct.
And that's the case as Ruby, and I know my time is up, I'll answer this quickly. Under the Ruby case and the Fernando case, it's clear that that does not affect the waiver enforcement as it relates to DeBrock Kemple or PEDCO. That relates to the separate litigation that Hartford could likely bring for being prejudiced by their insured's acts. But they did approve the loss. They did pay out their
So in other words, like what, in that scenario, the owner vis-à-vis DeBra, like subrogation would still, the waiver of subrogation would still be enforceable, but then maybe the Hartford could bring a breach of contract claim against the owner and say, hey, you shouldn't have done that. Like, I'm not going to pay this claim now because you've prevented me from recovering on the loss.
Right, you did not follow the policy language that we laid out to cover you. Yeah.
Okay. All right. Thank you.
That is my time. Thank you very much for your time.
Thank you. Mr. Winchester, I'll give you 6 minutes.
Thank you, Your Honor. Good morning again. May it please the court. Brian Winchester for third-party defendant Appellee Pedco E&A Services, now known as IMEG Corporation. We're requesting that you affirm the trial court's decision, and this matter intersects three different passions that I have in the law. A little bit of an insurance nerd, civil procedure issues, construction issues, and insurance law issues. As to the procedure issue, there's no brief, no argument, no appeal as to the dismissal of the third-party complaint against Pedco. We were brought in by DeBra Kumpel. DeBra Kumpel did not file an appeal. And plaintiff, on the other hand, had no direct claim against Pedco. They did not appeal or argue on appeal the denial of their motion to amend to seek to join Pedco as a direct party.
Well, they almost conceded that 8.1.2 applied there.
Well, that's what I heard as well, which brings me
But
then to...
in the brief, yeah.
Yes, and that's a lack of standing issue of whether or not a plaintiff, if not directly aggrieved, has standing to appeal the dismissal of the third-party complaint, which they do not. DeBra Kumpel had a direct claim against my client seeking contribution and full indemnity. They could have appealed, they didn't. So we're here as an appellee requesting affirmance, A, based on the procedural ground, B, on the construction ground. Judge Bergeron, you asked about needing a flow chart early on, and that brings to the point, this is a large construction project, and these types of projects are generally let design, bid, build. The owner enters into an agreement with an architect, the A201. The owner or the architect then enters into a sub-consulting agreement with the engineering disciplines, the contract between Pedco and the architect, BHDP. Separately, the owner enters into a general contract with Dana's Construction, and they include what's called the A201, the general conditions for construction. So it's through those contractual mechanisms that we get this project built, we get it constructed, and we get what's called a transfer of risk. And that's exactly what the waiver of subrogation is. Courts throughout the state of Ohio repeatedly have enforced the waiver of subrogation as a transfer of risk. And we'd ask the court to give effect to the intent and the plain language of 8.1.2. There's no dispute. Pedco is a consultant of the architect. They're identified in the owner-architect agreement as the engineering consultant. So the waiver of subrogation clearly applies. The other intersecting issue on this is the policy of insurance.
And sorry, just a threshold issue. There was some reference earlier. There was never a direct claim by the Hartford against you all. Is that correct?
That is correct.
Okay.
They sought leave to amend. The court denied their motion to amend.
And that wasn't appealed.
That was not appealed. While plaintiff's notice of appeal in this case references all interlocutory orders, you will note in the appellate briefing, not a single footnote, not an allegation, not even a fully fledged argument, not even a mention. The denial of the motion to amend was left untouched. And if we look at that third-party complaint that was brought by DeBra Kumpel, full and complete indemnity, which includes their fees. If they seek to enforce or file a cross appeal, that's their decision. We also had some procedural arguments of independent grounds to support the trial court's dismissal of the third-party complaint. One is the application of the anti-indemnity statute under revised code section 2305.31. There were independent acts of negligence alleged against DeBra Kumpel. They are prohibited from seeking indemnity by statute. The other is the economic loss doctrine. As I talked about that flow chart of contracts, they diverge. There is no contractual privity between Pedco and DeBra Kumpel that would allow them to sue my client. There are exceptions to the absence of privity in the economic loss doctrine. none of them even alleged here. While the trial court initially denied our motion to dismiss that third-party complaint, we feel they got it right. And quite frankly, it doesn't matter to me the grounds on which the trial court got it right, because the claims are barred against Pedco by Durant Couple. 1, the absence of privity, 2, anti-indemnity, and 3, the overriding waiver of subrogation that is clear, undisputed, and unambiguous. Going back to my third interest of insurance, I'm sorry, I got derailed there a little bit. The A201 waiver of subrogation references 11.3.2 as well. If we look at that, it references policies that were not in place during the construction period. The Hartford policy was in place during the construction period. It's Exhibit 8A to plaintiff's opposition of the motion for summary judgment. We can see the effective dates. We've heard the acknowledgement and the concession by counsel for plaintiff.
Now, it also says, or if after final payment, which I understand is, is it nebulous by the record whether there was final payment?
I believe it is. That
record?
issue was not addressed at the trial court, but we do have a policy that was in place during construction
Right.
period. So we don't need to deal with whether or not there was final payment or not. And then the other issue, the Hartford attempts to argue that their policy prohibits the waivers of subrogation. That language is ambiguous at best when it references you can't waive subro against an architect or engineer for their interest in the property. My client has no interest. Therefore, that exception to the exclusion doesn't apply. Any dispute between Hartford and its insured is not our business and not our fight.
What would be a circumstance in which your client would have an interest?
Typically, that comes about during the course of a construction project with what's called a builder's risk policy, whereby the owner, the architect, the engineer, all the contractors, and all the subcontractors are all insured for liability under that same policy. So we have a construction policy, whether it's builder's risk or owner-controlled insurance program, that's a specific management of risk where that would happen, where a contractor, an architect, or an engineer would have an interest. But in this case, they do not. This is a property policy, not a builder's risk policy. And again, we'd ask that the court please affirm the trial court's decision. Thank you very much. I think I've overstepped my time. I appreciate it.
Thank you. Mr. Ransell, you have about 2 minutes.
Okay, thank you. In my limited time, I'd like to discuss 11.3.2 because I don't think we've really gotten into it. And that's what I think is the main issue here is where does this policy fit? 11.3.1 or 11.3.2? And 11.3.2, I think, is clearly where the Hartford's policy fits. It insures property at or adjacent to the site by property insurance under policies separate from those insuring the project. And that's exactly what the unrebutted testimony of Andrew Clark of the Hartford, that's how he characterizes this policy, as a policy ensuring a separate policy from that insuring the project and a policy that is insuring property at or adjacent to the site. So it's the position of the Hartford that the Hartford's policy fits into 11.3.2 perfectly, and that provision has got the exception that I'm relying on here to the extent permissible by such policies. And as the briefs show, the Hartford's policy specifically prohibits waiver of subrogation against.
So if I'm
So how would
underst-
you, so how would you define interest in? Because wasn't that part of the policy?
Yeah, and I think my understanding is it's simply their involvement in the construction, involvement in the construction.
So it's not a
process.
legal interest in?
That's not my understanding of what it is.
Okay, what are you basing that on?
The plain language of the policy provision.
So in your mind, an interest in means that somebody is involved in it at all, rather than a legal interest?
Right, and I think maybe I talk about that in the briefs about how if we take the position of the appellees in that if it's asking for an insurable interest or a financial interest, then if we walk and take our way down that road to its logical conclusion, then that provision would never be applicable because
That's what it seems to me. That's why I don't understand.
it seems like if that's the interpretation that we give it, then it would never be applicable in any situation, and that can't be right because that would make the provision superfluous.
But I'm still not clear on what interest in is.
Your time has expired.
Thank you.
I do have a question, though.
Okay.
I want to go back to your discussion of saying that 11.3.2 applies, and it applies because of the language of the if during the project construction period, okay? And then you talked about under policies separate from those ensuring the project, okay? Was this a policy separate from ensuring the project, or was this a policy that also ensured the project?
Well, we have the unrebutted testimony of Andrew Clark of the Hartford, who's also a 35 witness, who testified that it was a policy separate from that ensuring the project.
Right, but he was saying that, but if I follow the logic of that, that means that there's another policy that ensured the project, and I don't recall that being in the record.
I don't recall if it's in the record either. My understanding that there was a contractors controlled insurance program.
Well, but by that reasoning, like, why wouldn't you have denied the claim if your policy wasn't covering what happened here?
Because this loss occurred post-construction. So once the construction's over, usually, typically, in my experience, those contractor-controlled insurance programs terminate, and then the regular property policy takes over.
So then, how do we factor that, what you just explained, into 11.3.2? If there's not another policy that's effective now because, I guess, the construction's over, there's not a separate policy, right? And forgive me if I'm not understanding this. Construction is not my bailiwick. I'm trying.
Well, I think the argument is that it was a policy that was separate from those ensuring the project, and that's true.
So it was separate at
regardless.
one point, and
Yeah.
okay, I understand.
And I think it's actually still true post-construction completion as well. It was never a policy that was ensuring or applicable to the project.
How are you defining post-construction completion? Basically that the work was done?
Yes, and
So
the
the
building was
final payment is
occupied.
not governing that?
Occupancy of the building and the testimony of the Hartford's general adjuster making a determination that the construction had been completed. But there admittedly isn't ample discovery in the trial court as to when construction actually, the date it was completed, when final payment was made.
Okay. Because I found it interesting, and I'm just going to put it as a footnote, you don't need to respond to it, okay? I just found it interesting that this is a contract for construction, and it's got these waivers embedded in it, right? And it makes sense during the construction period that you don't, if there's a loss, you don't want to get all hung up on all of this stuff, because then that'll stall the project into infinity and beyond, right? But if the construction period is over and done with, that the waivers are living past the construction period, and that was never raised. I just found that interesting. Again, I'm not a pro at construction, but I had a hard time wrapping my mind around that.
You want me to respond?
Does that make sense? No, you don't have to respond,
Okay.
because it never was argued. But I just found it very interesting that a waiver would live beyond the construction when that waiver is born out of a construction contract that's a contract for construction, and that waivers of subrogation would live beyond that, because the loss obviously was not related to the project, and it didn't take place during the term of the project.
And I can tell you why I didn't make that argument if you'd like me to go ahead. It's simply because.
I'll let the presiding judge decide if she wants to hear it or not.
I mean, if you would like to hear it, that's fine.
Okay.
In my experience as a subrogation lawyer in many states, that the courts have interpreted those waiver of subrogation provisions to extend beyond post-construction. So,
I mean, and it would have to, because otherwise everyone would suddenly have to like insure right after the project was completed if some defect were found that occurred during the project, right? I
See,
mean,
but
that's
this
gotta
is
be the
why I
reason.
found it interesting, because there is a provision there on the guarantee of workmanship. So it seems to me that when the project is completed, the guarantee of workmanship kicks in.
I think in certain circumstances, that's
So,
accurate.
so again, but that's, and that provision was in the contract, the guarantee of workmanship. So it seems to me that the waiver is trumping the guarantee of workmanship during the term of the policy. Now, once the policy term ends, then it no longer does.
Okay.
That was just my observation as,
Understood.
whatever it's worth. All right, thank you.
Thank you. Okay, your next case is the Geiler Company versus Board of Trustees of the Public Library of Cincinnati and Hamilton County. Okay, whenever you're ready, would you like to reserve any time?
I'll reserve 3 minutes, Your Honor.
Okay.
The little green button fell off.
Oh,
Your Honor, my name is C.J. Schmidt. Please the court. I'm here on behalf of the Geiler Company, and Reed Geiler, who's the principal of the Geiler Company, is here. The background of this dispute was the installation of what they call air handling units at an energy retrofit project at the main library downtown Cincinnati. It's hard to describe. There's some photos of these units in the record, but these are very large. The project, as you know, the public library downtown is an old building, and it required special engineering to get these units into the mechanical rooms where they were going to be installed. There were a little bit unusual in this case was the contract was let, and Geiler's contract was to install these AHUs, and instead of them purchasing the AHUs, the library went ahead and purchased these units separately. The contract for the Geiler Company was called TC-05, which we referred to throughout the trial, and the one that for the purchase of these units was TC-02.
I'm going to
Yes.
stop you there. Did the TC-05 incorporate the terms of the TC-02 or refer to it?
It didn't refer to it, no, Your Honor. Well, it did in that it required Geiler Company to review all the bid packages on this job site. So there were multiple bid packages, one of which was for the purchase of the AHUs, which was TC-02, and the other was TC-05. There was an electrical bid package and went on and on. But yes, I mean, it's.
And there are these provisions, and I'm fumbling to find them right now, where they talked about the AHUs will need to be knocked down, rigged into place and reconstructed. And I realize you point to some other provisions that might suggest a contrary result, but ultimately, like, you had a trial on this, like it wasn't summary judgment, and you were able to bring in whatever evidence related to the meaning of the contract, right?
Exactly, Your Honor. I mean, we had a trial, 3-day trial in front of Judge Nestor. We presented all the evidence, and in this case, I believe the section that you're referring to about the conditions, the way these contracts work is that there's a pre-bid meeting before the bidders were there. There were multiple bidders present, and at the pre-bid meeting, there are questions that in this case, the engineer had listed the topics to discuss so that you could submit your bid. And in that, there was a subsection G of Addendum 1, which becomes part of the contract once the contract is signed, that all becomes part of the contract. Also part of that is a section called clarifications, which you can submit written questions to the engineer, and they can answer those questions. And the idea or the issue of fitting these AHUs into this building was a major issue.
Well, and that's where I'm getting at. Like, I can see how you could look at those two provisions and say, these seem in tension or in conflict. And that suggests perhaps an ambiguity in the contract, which would need to be fleshed out based on extrinsic evidence at trial, and you had that trial, right? Like, am I?
No, well, you're right, Your Honor, but we don't believe this contract is ambiguous. I mean, that clarification, which amends, which answers the questions that the bidders brought up at the pre-bid meeting, directly addresses this. I
Well,
mean,
but so does this pre-bid meeting. It says they will need to be completely knocked down, rigged, and reconstructed.
Exactly, this is what they were told was going to be an issue at this, in this project.
Mm-hmm.
How are we going to get these AHUs into the building?
Right.
And who's responsible for taking these things apart?
Well, it doesn't really say in the contract who is responsible. And it says will have to be knocked down, reassembled, et cetera, et cetera. It doesn't say whether it's the manufacturer or the contractor, correct?
Well, it says in the clarifications, I believe it does. It says, yes, the unit reps have walked the spaces, understand the limitations, have worked with the engineer to size the units to accommodate the tight working conditions. That's what the contract says. That addendum, the clarifications, was made part of this contract. I mean, there was testimony regarding what the parties understood this to be, but what we think that this makes this contract pretty clear. The reps, the engineers, Moats, who was hired by the library, and the unit reps, who were the EAP, knew what the problems were with this contract or these units and how to get them in, and they sized them accordingly. That's not what happened. They came fully assembled. I think they breached the agreement. I think this agreement is.
Well, so then that gets to your notice issue, and the trial court found that your client did not provide requisite notice under the contract. And I realized there was the email that is essentially complaining about this. But, I read that email and I don't see what I would expect to see in a claim for modification of the contract for an overage payment, because it doesn't monetize it, and there's not any other detail related to that.
Well,
So can you address that?
Yes, so 15, I think it's, let me find it here, 15.1.1, just says what is a claim? And it says a claim is a demand or assertion by one of the parties seeking as a matter of right payments of money or other relief with respect to the terms of the contract. And then it goes on, and I don't think it's applicable here. But what that says is, and it has to be in writing, the email was in writing, and it's an assertion by Geiler that these units arrive fully assembled. I think that's what the email says. This is not our requirement. We don't have the men to take these units apart. That's not I don't understand the library's argument that somehow we're supposed to put in a specific dollar amount. We didn't know.
Well, but then if that's your assertion, like, hey, this is not our job, then why did you do it without getting the library to agree to pay it? Like, that's the whole purpose of the change order.
Well, we emailed them. If you read the emails, they clearly thought it was supposed to show up disassembled, and the email chain, and then they eventually denied it. They said, no, it's your job to take these apart.
So you should then say, we're not doing that, not our job.
We can't do that. The contract specifically requires us to complete this job. And we cited to it. It's, I think it says 15.1.3 says until you get resolution, you have to complete this contract. We would have been in default on the contract if we had refused to disassemble it. We had to hire extra or bring on extra fitters to take these units apart and reassemble them in the AHUs.
Right.
So this contract required us to complete this job. We were actually supposed to get it done within a certain period of time because they had to turn the units on to keep the heat on in the building. So, I mean, we told them this was not our job. This isn't what was required of us. And they immediately, I mean, you can see the emails, and well, first of all, the one guy said he thought it was, they weren't supposed to show up disassembled. And
The other email says, somebody from Mott's said that the documents make it clear that rigging and assembly of the air handlers were discussed several times and is it appears responsibility of the mechanical contractor. What happened after that? Is that in the record? That was in
After the
October
email that
2019.
I'm sorry, Your Honor. After the emails, that email back and forth, and we got the formal denial, I think on October the 21st or something like that, we went ahead and finished the project, and then we submitted our bill for the additional time. One of the things they say, how much is this going to cost? Well, we didn't know. We had not even planned on doing this. So we submitted it to them. Under the way the contract's written, they're supposed to prepare the change orders. Moats is, not the the one and the same. And so we submitted the email, or we submitted the bid or the time to them, and we did the job we were supposed to. We had to have these units in there. But I'm trying to go back to your question. So that's the way the email stream worked. And they kept saying, no, this is your requirement. And they pointed to the section of the addendum number 1 that favors them, although it doesn't say who's going to pay for this. And we said, no, wait a second, this agreement says this. And it was always our understanding, I mean, this gets into our negligent misrepresentation claim, is at the bid meeting, after we looked at the bid packages, which included the one at TCO2, which clearly says these are going to come in
But
split.
at that time, TCO2 had not been signed, right? So it wasn't a contract.
It was not a contract, no. What it is a bid packages.
No, I understand.
Under state law, they have to publish all the bid packages. Our bid package said we're supposed to review all those agreements, which we did when we're assembling our bid, which we did. And in that one, it clearly says that they're going to come disassembled. And then I think what the term art was knockdown or splits and fit through the doorways. With that, and then at this meeting, Moats said, hey, if you have to disassemble them, it's on EAP, which is the people who sold the library the air handling units. So, I mean, they presented, it's either one way or the other. Either the contract is correct.
Yeah, I understand. I want to get back to the notice.
Okay.
Because one of the things that the trial court determined is that the procedure that was provided in the contract had not been followed with regard to this issue. How would you address that?
I believe the trial court said in its findings of fact that we did not notify.
It used the letter from March 27, 2020 as the notification moment. And
Yeah,
and because of the timing of that letter, then it was considered untimely.
Correct, and our position is no, we notified you almost immediately when these units showed up fully assembled, or that we were told they were going to be fully assembled.
And I believe you argued, Sasha, at the trial court, you argued that that was the notification period, right?
That's correct.
But then there was also the letter, and then the trial court makes a determination on which one they deem to be the notification period, right?
That's correct.
Okay. And I think your argument is just that, I guess what you're arguing is only that one serves. And So if we were to look at that one as serving as the notification, does it comply with all of the requirements under the contract in order
The
for you?
first one or the second one?
The one that you're, the first one, the one, with the email. So you have the
The-
email, and then you have the 2020 letter.
The-
Your position is that the email serves as the notification.
That's correct.
The trial court determined the letters served as the notification and found it to be untimely, okay? So if I was to go back to the email and use that as the notification period, there was also requirements with regard to disclosure of costs and things like that. So how do you fit into, what is your position on how you fit into all the requirements on the claim if that was to be the notification? Because there's other requirements besides notification.
The notification, the email notification, which I believe complies with 15.1.1 of the agreement, is that we're just supposed to put them on notice that this is not, well, in this case, this isn't ours to do, and is what the email. The defect, if anything, in that notice was it's that Doug Weberding, who works for Geiler, sent it only to the library. He didn't send it to Moats. And under the agreement, it says you have to get it to send it to Moats.
Right.
The library's witness testified he immediately sent that to Moats, and obviously, because Moats responded immediately. And then there was some back and forth internally with Moats, and then they sent their final denial like 20 days later, which was actually untimely also. But
Mr. Schmidt, you are at 15 minutes now. If you'd like to wrap up, please.
yeah, Your Honor, I think, or judges, I think in this case, I believe the agreement is clear under the clarifications provision that these agreements were going to come disassembled. And not only that, I believe that there's a clear negligent misrepresentation claim here as a matter of law. The facts are not in dispute, that the library presented us with false information that we relied on, and we were damaged. And under Ohio law, that's, even though that we're in privity of contract, we have a negligent misrepresentation claim that is still, the trial court erred in dismissing, and we'd like that to be reversed also. And I have nothing further. So I'm at no rebuttal.
I'll give you 2 minutes for a rebuttal.
I don't know if I need it. Thank you.
I will give you an extra 2 minutes as well.
Appreciate it.
May it please the court, Michael Friedman, on behalf of the appellee, the Board of Trustees of the Hamilton County Public Library. Judge Bergeron, to address your first question, you are correct. Subsection G clearly states that the contractor, and this is in future tense, the contractors will have to completely knock down, rig into place, and reconstruct the AHUs. Geiler has done very well to try to muddy those waters, but it's very clear in that.
Well, but I think, you're saying it's completely clear in that direction. He's saying it's completely clear in the other direction, which is not uncommon in contractual disputes. The trial court, to me, seems to have said, I'm not sure. I think this might be ambiguous. Like, let's have a trial on this. So we have this trial, and I presume at least part of the purpose of the trial was to flesh out any extrinsic evidence that would shed light on the meaning.
Correct, and I don't believe that Geiler provided extrinsic evidence to support their point. As it comes to the breach and the actual interpretation of the contract, Dave Wayhoff, who was the professional engineer on the project from Moats, testified that at the pre-bid meeting, they specifically walked through that the HVAC contractors would have to disassemble and reconstruct these. And that was one of the main purposes of that. In fact, it's the scope overview. Subsection G is in the scope overview of that pre-bid meeting walkthrough. It was an important point. And he said that that was a clear point made to everybody there. Geiler is relying on a answer from a TCO2 contract, which was not incorporated into this contract. And the more important point is the contract itself in this case, the TCO5 contract, specifically requires, and the basis, for their claim and also for their negligent misrepresentation claim is that they had to look at other bidding documents. Well, Section 3 in the A701 portion of the TC05 contract specifically requires that if there are any ambiguities or differences in interpretation as it relates to different bidding documents and the bidding documents for TC05, it is the obligation of the HVAC contractor to bring that to the attention of the architect and engineer, and that the architect and engineer would then revise the bidding documents to clarify that. And specifically, it states that the HVAC contractor in this case, if they do not bring those, if they see any ambiguities or any differences, and they don't bring those to the attention, they cannot, shall not rely upon those. So not only for their interpretation is
Well,
that.
but I get that. So we get, but I think there is some tension in the documents with the language that they cite as to like who's supposed to do what on this. And so they get to this point, I understand. They get to this point, they look at the HVAC units, they're like, oh my goodness, these aren't gonna fit. What do we do? They provide you all the notice, you all say, it's your job. And so getting back to my question that I asked opposing counsel, like, what were they supposed to do at that point to preserve their claim if they disagreed with your assessment?
Judge, I think you hit the nail on the head on one option, and the trial court observed this as well in a colloquy with opposing counsel, in that they could have stopped work. They said, no, we're not doing this. This isn't ours to do. However, and to Judge Zayas, your point, and this was brought up through the entry, Geiler has argued that the technical deficiencies in the notice were the only reason. That was not the basis for that. The court brought up in their entry the technical deficiencies of not supplying it to both to the engineer and to the owner. However, they also found that the March 29th to 2020 letter and notice was the actual notice of the claim. And if you look, the evidence presented at trial.
That's the letter that gives the sum of the.
Yes, and that
the
in
additional
form and
costs.
substance is similar to the other claims that were submitted in this exact contract that resulted in executed change orders. And these claims and the change orders actually took place, I think, August to December of 2019. The exact time that this was going on, that they claimed that they found this and they sent this email, the letters that they supplied to the owner, the library, and the architect in those instances all met in form and substance the same as the March 27th letter. They didn't provide any evidence that they submitted email claims for any of these others. They all had very firm, they have estimates of costs, and they went through. And so that fits the March letter. Again, the August email only says this isn't ours to disassemble. If we were to take every email between parties about disagreements and say that that's a claim, there would be 1 million claims on every project. And important, and the brief may sound like I'm reiterating Foster Wheeler a bit, but I think it's a very important case for all aspects of this case. But the important public policy understandings and opinions that underlie the holding in Foster Wheeler in the change order process is that you have to give owners the opportunity to weigh different options, especially with a public entity and public money. You can't do what Geiler did in this case, which is they say, oh, we submitted an email. They go ahead and do all the work and then stick us with the bill.
But
Foster
didn't
Wheeler
the,
says-
I mean, how would you respond to your opposing counsel's argument that the contract required Geiler to continue doing the work despite the
Well-
either lack of response or the negative response to the email in August?
I would say this. The notice argument that Geiler is now relying on was, from what we've seen and everything else throughout this case, was somewhat created during trial, and a clever argument, but I don't think it meets with the basis of and the spirit of what happened in this contract and the language in the contract. Okay, a notice, but then there has to, the obligation in the contract is on Geiler to substantiate their claim. And to Judge Zayas, your point earlier, what did they do after that? The record doesn't have any indication that they did anything other than do the work. There's no other evidence that was presented that said, hey, it's gonna take us this long to do this, here's an estimate. The testimony in the trial was that they did not prepare time and materials tickets, they didn't do daily production reports. All the evidence to support their claim was created basically after the fact. They put together spreadsheets based on numbers they said they had on the work. You would think that if it was something this major, that they would have, number one, had out front a estimate of the cost so that the owner could weigh
See,
that.
but I thought about that, and I don't know that that would have been easy. If it came all together, until you start breaking it apart, that's when you know, like, how much you have to break apart. As I understand, there was testimony of, I think, some fans or something that had to be broken apart, and the testimony is that that's just not normal.
Well, normal or not normal, I can't really speak to that. I would say this.
That's how I understood the testestimony, that was not, you know.
That was from that, that's fine that they would say that it
I'm
wasn't
not-
normal.
Yeah, I'm not
But
just saying,
nobody-
I'm not vouching for the testimony.
Understood,
I'm
yeah.
just saying
Understood, yeah.
that, you know, I think it highlights the issue of, like, how does one know until one gets into it?
Well,
And I'm not saying that, you know, it's just an interesting point that it isn't until the tail end that there is.
Your Honor, I would say this to that. I'm not in the trade, so I couldn't tell you. I would say this, nobody forced Geiler to bid on this project. They clearly had an estimate for the reassembly and the rigging into place. How do they get to that?
Well, I mean, that's not what's in front of us, so that they got forced. I mean, that's
Oh,
not
no,
really
understood,
helpful.
but to your point of, every other change order they had, which included asbestos removal, all these other things, they were able to give some type of estimate on this, yet they didn't on this, and they're just now coming, actually, they did when they were finished, but they could have, there are multiple ways, they could have come up with an estimate and said, this is.
They could have just done one and then said, okay, it'll take us X hours to do all of these.
Very well could have. They could have done one as an example. They could have said, we don't really know, but and again, it was just taking off screws. A lot of screws, I won't disagree with that. They said, okay, multiply it by this is how much it's going to be to get it through there. Or they could have said, hey, this isn't ours, you guys didn't contract that, and if they said that, then they could have worked with the library about maybe doing, you know, time and materials ticket or something along the way to say, this is how we're doing that. But the one thing they can't do, and Foster Wheeler kind of makes his point, is you can't just go ahead and do all the work and then say, here's the bill, public entity, you've got to pay it. You know, there is a thing where the library has a right to assess that. Now, again, we don't believe that the manufacturer breached, but in this case, maybe if they did, accepting.
Well, yeah, I'm not sure about that. Because wasn't there a requirement for things to be labeled and all of this stuff so that it could be knocked down and put back?
Yeah, well, I would say this, the submittals, and that going to that point, came after that point. The submittals that came in June did say that they would ship as one thing. I don't know about how much was labeled in terms of that, but the big thing on that is that the requirement's clear in the contract that Geiler actually is in charge of coordinating this entire process. So to the extent that anything wasn't, they should have been working hand in glove with the manufacturer from the beginning. That was their responsibility. That's what the library, in fact, they said in subsection E, they were supposed to treat them as if they bought them themselves. So, you know, I understand that, but again, getting to the kind of notice and what would have happened there, I think the library has to be afforded the opportunity to do that. And Geiler, again, has the responsibility to substantiate their claim with the costs and everything like that. So even accepting this kind of post hoc, this is our claim, or notice of our claim, well, they needed to do something more. The emails that were in that record demonstrate, well, we don't disagree, this isn't ours to do. Immediately, Moats responds, chapter and verse, this is your responsibility, and then nothing. I mean, to me, that would seem to be that, okay, there's a disagreement, but we went ahead and did the work that we were required to do
So
under
it
the
seems to
contract.
me that based on your argument that perhaps you would say that we don't need to even get to whether they were required to knock down or not because of the deficiencies in following the process for any monies. Is that what you're saying?
I mean, I think, honestly, I think our argument is the reverse of that. I think it's very clear and unambiguous, the language of that contract. That's more of an ancillary, but even if it, you know, whatever, they did not follow the appropriate procedures within that. But again, and going back to the clarification that Geiler has said makes their case for them. The clarification was about the actual mechanical rooms. And the project engineer on this, Mr. Wayoff from Modes, testified that the tight working conditions that are referenced in that answer have to do with the actual mechanical rooms, not how they got in there. They wanted to make sure that the units, as built, could actually fit in the spaces. These are cramped old rooms that were built up with the original units. Now they have to retrofit and fit into that. So they needed to make sure they couldn't have them disassembled, brought in, and build, and all of a sudden it doesn't fit the rooms. Also, it was supposed to, with this, the way they were using the old vents and everything, they were big enough to supply enough air to do that. So that's what the unit rep question is about. It's not about whether or not knocked down and who was supposed to disassemble. Subsection G is a call to the contractors, and specifically the testimony from the project engineer of Geiler, Mr. Weberding, indicated that everything within subsection G was performed by Geiler under the contract, except conveniently the complete knockdown. And reading a contract in totality, taking one duty within a parenthetical and removing that out and saying, oh, that's not our responsibility, but everything else within that is ours, doesn't make any sense and is against the contract interpretation law.
And I just want to follow up, make sure I understand. So they sent the email that says, we don't have the labor to do this, not our responsibility.
Mm-hmm.
You all respond, yes, it is. And then at that point, there's no response from them? They just start working?
I believe, yeah, that they just went ahead and worked. I don't recall, but I don't believe that there was record evidence of any pushback further.
I guess that's my question, is there's not an attempt to resolve that dispute, at least via email back and forth, or to protest it or whatever. It's just, I'm asking the question.
I would say in terms of the record evidence, I don't believe there's any email further follow-up on that, but obviously they worked and got it done, so.
Sure.
And I want to make sure that with my time, the one other thing, the damages portion of this, again, one of the exhibits or documents that Geiler relied upon to prove theirs was a list of all these items, and they highlighted portions that were out of scope. Half of, or a good number of them included things that had to have been part of the original scope. Navigating the stacks to get to the room, elevator trips. Even assuming, taking that their argument that it was supposed to come disassembled and that's the way it was supposed to be, they still would have had to navigate. They still would have had to take the elevator trips. It doesn't have any difference on that. And, the law is pretty clear that it can't be conjecture or speculation. You have to prove your damages, and I don't believe they did in that case. So with that, I believe my time is up, so thank you very much.
Just to respond to Judge Bergeron's, I think, comment about extrinsic evidence. The only evidence they presented was Mr. Wayhoff, and he testified, oh, that's what that contract means. Our extrinsic evidence to show that different than that we presented at trial was TCO2, which said they were going to arrive disassembled. At the pre-bid meeting, Mr. Wayhoff and Mr. Haney, who were representatives of the library on behalf of Motes, stated that if these units if they required disassembly, it would be at the cost of the manufacturer, EAP. And then we also presented an expert who went through all the contract documents, who said that that these units were going to arrive disassembled or in knockdown state.
Well, but then,
there was plenty of extrinsic
well,
evidence.
but what I'm saying is, if the trial is about extrinsic evidence, then it's more of a manifest weight challenge than it is de novo, if we're relying on that. That's what I'm trying to wrap my head around, because typically when we get these, contract interpretations, it's just cross motion for summary judgment. But you all had an actual trial.
Yes, we did.
Yeah. Okay.
Your Honor, we believe that contract, because it was a clarification section, actually explains what occurred, or what that means, that subsection G, which is part of the contract. I think you have to read where the trial court went wrong was it didn't read the contract as a whole. It didn't take into effect those Also, that extrinsic evidence goes into our claim for negligent misrepresentation. And I think that's all I need to address, unless you have anything more. Thank you.
Thank you. That concludes our session this morning. Thank you.